So today I wanted to chat about what's called the SRIA process. The acronym is SRIA. What on earth is a SRIA? That acronym is for Standardized Regulatory Impact Analysis. And for those who are involved in regulatory work at California's 200 plus, rulemaking agencies and departments and boards and commissions, you may have heard of SRIA, which is done for so-called major regulations. So under existing California law in the government code, in the APA, the Administrative Procedure Act, all regulations are required to have an analysis of the potential economic impact of that proposed regulation. Specifically, Government Code Section 11346.3 requires a state entity that's proposing to adopt, amend, or repeal any regulation has to assess the potential for adverse economic impact on a on California businesses as well as individuals. Now, these rulemaking entities must also avoid the imposition of unnecessary or unreasonable regulations or reporting, record keeping, or compliance requirements. And unfortunately, this short analysis is done by completing what is called an economic impact statement, which is basically a 5-page sort of fill in the blanks form, which is probably sufficient for most regulations. And then that state entity is going to, prior to submitting its proposed rulemaking package to the Office of Administrative Law, they're going to begin the formal rulemaking process and consider the proposed regulations impact on business with consideration of industries that might be affected, such as the ability of California businesses to compete with businesses in other states. And the state entity has to consider information even supplied by interested parties. So what exactly does this economic assessment include? Well, basically the state entity has to assess whether and to what extent the proposed regulation will affect the creation or elimination of jobs within the state, the creation of new businesses or the elimination of existing businesses in California, the expansion of businesses that are currently doing business in the state, and the benefits of the regulation to the health and welfare of California residents, as well as worker safety and even the state's environment. About a decade ago, the legislature determined that for more significantly impactful regulations, estimating about 10 or 12% of state regulations, basically a more thorough fiscal analysis ought to be done. And so the legislature created, of course, by statute and added to the APA, the so-called SRIA process, which is intended to provide a much more comprehensive analysis, but it only applies to so-called major regulations. And Government Code Section 11342.548 defines a major regulation to mean any proposed adoption, amendment, or repeal of a regulation that'll have an economic impact on California business enterprises and individuals in an amount exceeding $50 million. In other words, since about November of 2013, whenever a state entity proposes to engage in a major rulemaking, that entity has to prepare a standardized regulatory impact analysis, a SRIA, and there are regulations that were adopted by the Department of Finance pursuant to the government code. And generally speaking, the SRIA provides for, as I mentioned, a more detailed analysis of the compliance cost as well as the potential health benefits of the regulation. And so, it poses the question, why is a more detailed analysis required? Well, according to the statute, analyses conducted pursuant to this section are intended to provide agencies and the public with tools to determine whether the regulatory proposal is actually efficient and effective in terms of implementing the policy decisions that were enacted in statute or by other provisions of laws to be done so in the least burdensome manner, and that these regulatory impact analyses need to inform the agencies as well as the public of the economic consequences of regulatory choices, not just reassess statutory policy. Moreover, the statute says that the baseline for regulatory analysis should be, or has to be actually, the most cost-effective set of regulatory measures that are equally effective in achieving the purpose of the regulation in a manner that ensures full compliance with the authorizing statute or any other law that's being implemented. So pursuant to Government Code Section 11346.36, the Department of Finance adopted regulations in conducting the SRIA. And so these regulations help the state agencies to assess and determine the costs and benefits of the proposed regulation to be expressed in monetary terms to the extent that that's feasible. Also to compare proposed regulatory alternatives with an established baseline so that the agencies can make analytical decisions about the regulations and determine that the proposed action is in fact the most effective. The SRIA process will hopefully determine the impact of the proposal on the state's economy and businesses and the general public welfare, and also assess its effects on the general fund or any special funds of the state, as well as affected local government agencies. The SRIA also will help determine the costs of enforcement and compliance to both the agency, again, in terms of cost of enforcement, and the cost of compliance by the affected businesses or individuals. So that SRIA has to be included in the initial statement of reasons of the regulation that's submitted to the state entity, to OAL and interested parties, and that begins the formal rulemaking process, of which the SRIA is an important part for so-called major regulations.